I would like to thank Dennis and the South Carolina Emerging Tech Association for asking me to speak on this topic. As Dennis had mentioned, I've been involved in the legislation of blockchain and emerging technology since about the end of 2019. A little bit about my background. I am a program coordinator and assistant professor for the University of the Cumberlands. I run the Masters of Global Business with Blockchain Technology program, and we have just recently added a master's certificate in blockchain and business as well. All right, so I posted the PowerPoint in chat, so it'll be one of those kids' books where you can follow along in the book as you listen. I'll make a beep when it's time to turn the page. But as I was mentioning, I am the program coordinator, assistant professor at University of Cumberlands for our blockchain program. Our program is, as far as I know, recently the only business and blockchain program globally that has been accredited by the IACBE, which is an international accrediting council for business education. So we are one of the first and only programs to receive that accreditation, as well as being named one of the top 10 blockchain programs in the country, along with such organizations or universities such as MIT, Berkeley. So a small private college in Kentucky is been at the forefront of this emerging technology wave as it's coming through. A little bit more about my background. I am also the Director of Government Affairs for 10XTS, which is a blockchain fintech, regtech company that works on risk, governance, and compliance within the fintech and the blockchain field. My past is actually in business administration, or I'm sorry, in public administration. I received a doctorate in public administration, but I worked for the state of Kentucky in a regulatory aspect with our public protection cabinet, where I dealt a lot with administrative regulation and policy. I've also been a city manager for 2 cities in Kentucky, and I saw the terminal operations for the Greater Cincinnati Northern Kentucky Airport. So I've had a lot of past experience in government, specifically with policy and regulation. I do have 1 year of law school training, which just makes me dangerous and does not make me a legal expert. So what I'm going to discuss today is more along the lines of a lecture that I provided to my students. We just created a legal and regulatory framework of blockchain for our program, and this was mentioning, this PowerPoint is based on the lecture I provided to some of our students just recently on the UCC. As previously mentioned, I've worked in the state of Kentucky on legislative matters related to blockchain. I aided in the creation of our Kentucky Blockchain Working Group, which was formed in statute back in 2020. I was named one of the statutory members representing academia on that board, and I've been the primary researcher writer for 3 of our annual reports that we have issued on the state of blockchain and its potential utilization, implementation, and adoption by the state, either in a capacity to make it more blockchain friendly, or for actually our government agencies to employ blockchain in some type of way. So that's a little bit about my background. We tried to implement the Wyoming, Texas UCC changes back when Wyoming and Texas had done that to create the SPDI institutions within Kentucky. We received pushback from the Kentucky Bankers Association, primarily because they didn't like it being called a bank. They had no objection to the actual institution. Their biggest pushback was calling the institutions a bank. So we had tried to work with them, and then we have a member that works with the UCC that is one of the senior members. And as Dennis had mentioned back in, I believe it was 2021, with the Kentucky Bankers Association, he spoke discussing how he had stopped these other efforts and that the UCC was coming to the rescue to the banks to help them better understand how to work with cryptocurrencies and blockchain-based measures of value or exchange. Finally, that did come through. It was promised in 2022, which it did not, I'm sorry, in 2021, where it did not come to fruition, but they did do that over this past summer, and they issued the recommended amendments to the states for passage. Quick background on the UCC. The Uniform Law Commission was founded in 1892 to aid in creating uniform statutes across states to aid in commercial transactions, as well as other uniform statutes. The first draft of the UCC as we know it began in 1945 with the American Law Institute and the ULC, with the first enactments of what we now call the UCC in 1952. For those that are attorneys here, one of the major legislative foundations in your contracts courses is a study and understanding of the UCC. The UCC covers, again, commercial code covering commercial transactions. Back in the 40s and 50s, when this was first created, we had more of a consumer goods industry. This changed in the 90s, so a lot of changes were made and amendments in the end of the past century because our economy switched more to a service-based, and now we have to update it for the new digital economy. So that is where this came from. The process began in 2019. There was a participation amongst a large group of lawyers and others involved with the UCC, as well as advisors from private technology, government agencies, even had some foreign participants from multinational law reform organizations and technology-related law firms. So this was a big process that began in 2019 to try to get an understanding of how what we refer to as digital assets or cryptocurrencies can be utilized within commercial transactions. Other UCC, or I'm sorry, other ULC uniform codes that have been passed besides the commercial code. This is not just centered on the commercial code. You have the Uniform Anatomical Gift Act, Child Custody Jurisdiction Enforcement Act, Interstate Family Support. One of the more recent and well-known is the Uniform Electronic Transactions Act, which dealt with contracts in electronic form, such as how to handle contracts through like DocuSign and other electronic means. And then recently there was a revised Uniform Fiduciary Access to Digital Assets Act. Talk about that a little bit more as we go along, but with the digital assets, that plays into some of the definitions that we will see as we go through this. The UCC wording, besides the early changes made by Wyoming, Idaho, Texas, and Nebraska, who changed their UCCs to include digital assets. New Hampshire passed an earlier version of the entire UCC. Kentucky, we had it proposed last year, but it did not come out of the Judiciary Committee again because it was not finalized, and we had that pushback from those that were very much involved in the process, said wait for the final version. Iowa, Nebraska, and Indiana did pass an earlier version of the CER, which is the Controllable Electronic Record Proposal, which we'll talk about. And Arkansas and Texas did pass an earlier version of the CER, specifically for virtual currencies. Currently, as of last I checked, 23, well, let me put it this way, 22 states have proposed the UCC amendments. The 23rd is DC, which of course is not a state. So quite a few have proposed the full passage. Among them is Texas and Nebraska, which I had mentioned have changed theirs from the beginning, somewhat like the Wyoming proposals that initially were passed back in 2019. One of the issues which has come up recently, and we'll go into a little bit more later, is the vetoing of the UCC amendments by the South Dakota governor, but we'll circle back that in the end. So these emerging tech amendments respond to a market concern about lack of definitive commercial law rules involving transactions of digital assets. This especially relates to negotiability for virtual currencies, certain electronic payment rights, secured lending against virtual currencies, and security interests in electronic fiat money, which is known as central bank digital currencies, as well as the virtual non-fiat. The first main portion, which is what many of us are concerned with in the blockchain cryptocurrency emerging tech world, is its handling of digital assets. This first section of the amendment concerns a class of digital assets. They are defined as a controllable electronic record. This includes virtual non-fiat currencies, NFTs, digital assets in which specified payment rights are embedded. The amendments provide for the CER to be in effect a negotiable interest. The reason for the definition of controllable electronic record is to discern it from other digital assets. As I mentioned before, that other uniform fiduciary assets of digital assets that defined digital assets in a much more broad range. That included any asset in a digital form. This considered accounts such as social media accounts, email accounts, communication accounts, considered all of these as digital assets, which are intangible, provide an intangible ownership. So this is specifically related, this definition, to controllable electronic records, which again allow these to be negotiable. They provide a security interest in CER to be perfected by control, and for security interest perfected by control to have a priority over a security interest in the CER perfected only by the filing of a financing statement. Currently, in the UCC, when you have a security interest or transaction, this is usually only perfected, which means completed through a filing with the state or the proper authorities. However, the filing specifically refers to current fiat currencies, which are considered tangible because most currencies also come in a tangible form. So this had to be completed to identify the process for an intangible measure of value, such as a virtual such as a virtual currency, and this can be done now by control, and the UCC goes on to define how control is established. The amendments also address security interests in fiat money. That's virtual currency, as we talked, the CBDC. So a little more, a controllable electronic record is a record of information in electronic form that is susceptible to control. For a person to have control of a CER, they must have the power to enjoy substantially all the benefit of a CER, the exclusive power to prevent others from enjoying substantially all the benefit of the CER, and the exclusive power to transfer control or to cause another person to obtain control of the CER, which is the controllable electronic record. The person must also be able readily to identify itself to a third party as the person having these powers. Again, there are a lot of more aspects of this control and other items that go along with that. I'm not going to get into that. We might be able to cover it in discussion later, but identification can be made other than by name, including cryptographic keys or account numbers. The exclusivity requirement is satisfied in most instances, even if there's a sharing of these powers through a multiple signature or similar arrangement. That means you can have multiple owners, which then would define, exactly who has control, or do all the signatories have control. So that is covered in the UCC as well. Other portions of this include the rights of a transferee of a CER, tethering and certain payment rights associated with the CER, which also leads into the potential for secured lending, account debtor discharge, and also the identification of the choice of law if there is a contractual dispute over exchange or transactions dealing with controllable electronic records. Now, besides digital assets, there are also other sections that deal with electronic money, chattel paper, negotiable instruments, payment systems. And then there is a host of miscellaneous amendments that adapt amendments within other sections of the UCC. We were specifically referring to the new Article 12 that's being proposed, but Article 9, which deals with security interest, also had to be amendment to reflect a lot of the language and the new definitions within the Article 12. So it ended up being, I think, a 130-page amendment or document to be amended and adopted by states. A lot of that was just fixing words, but the predominant portion of it is the new Article 12 and the changes of Article 9 to reflect that. So basically, what does this mean? Originally, our security interest, our financial system was created with a basis of real assets or tangible assets. Then you had exchange through contracts or securities, bonding, etc., which created a financial asset. However, what we have now is we have intangible assets, such as cryptocurrencies and other forms of electronic assets that are intangible and only exist in an electronic state. These amendments allow this new electronic world, for lack of a better term, or electronic financial world, to be managed and understood through the same processes that we had before, except we're building it on intangible assets, oftentimes the CERs, and then through what are called controllable accounts and controllable payment intangibles. These create the ability to create promissory notes, e-promissory notes, which allows the lending versus the controllable record or the virtual currency, as well as the security interests, to be understood and better managed. Now, the important part of this, really, as I mentioned at the beginning before I went into the controllable record and the amendments, is that the banking industry is a very conservative industry. I've had discussions, one with the Kentucky Bankers Association, and recently, as I'm also a member of the legislative committee for the Florida Blockchain Business Association, we talked with the Florida Banking Association. Banks want to know specifically what they are doing, how they're doing, and what they're allowed to do. So the more specific their guidance is, the happier they are, the more comfortable they are with the process. So this is one of the main reasons why the banking associations are supportive of the UCC amendments. Actually, in South Dakota, where I mentioned that the governor vetoed these amendments, the South Dakota Banking Association has come out against that veto because this actually provides a better framework for banks to understand and work within the virtual currency or controllable electronic record to digital asset space. This gives them guidance, and it also provides an understanding of how these transactions, commercial transactions, will be handled by the courts and by the law. That somewhat brings us into the next point, which is why the South Dakota governor vetoed it. Her brief veto message was the concern over the way that Bitcoin was defined. There is a concern that Bitcoin was specifically left out of the definition of money. Therefore, potentially also stating that this is banning or preventing Bitcoin and other virtual currencies from really being part of the economic financial system and opening the way for a central bank coin. That is really not the case. For one, the definition of money only applies to the UCC. In fact, this does not provide any regulatory oversight in general, does not specifically address cryptocurrencies. It's just a way to utilize them within the commercial and transactional nature that they were attendant. If the entire point was to ban or keep the virtual currencies out of the financial system, there would be no need for the Amendment 12, because only fiat money would be able to be utilized in transactions somewhat like it is now. So the entire purpose of all of this was to identify the best way to utilize virtual cryptocurrencies in transactions, lending, and security interests. So Bitcoin, for those that have, and I'm sure most have, that have read the Satoshi paper, if you read, and I have some of the statements on the slides if you have them, but Bitcoin, if you look at the introduction, is set up as a transactional system. It is not specifically set up as a money. It's a much broader system or process to be utilized. Now, it does use the word cash in the title, but cash is not money. Cash is actually an accounting term that is utilized, such as cash accrual. So, Bitcoin as transactional nature is more a unit of accounting and recording transactions. And I provide some of those quotes from the white paper, as well as the definition of cash accounting from the budget office. According to UCC, money means a medium of exchange currently authorized or adopted by a domestic or foreign government. The term includes a monetary unit of account established by an intergovernmental organization or by agreement between two or more countries. As I had mentioned, the concern was because Bitcoin had been adopted by the Central African Republic and El Salvador. The concern is that Bitcoin should be recognized as fiat currency in the UCC. However, my interpretation, again, this is why we have attorneys to interpret the law. I think that the defining of Bitcoin as fiat money would cause bigger concerns for Bitcoin as fiat currency or money is heavily regulated by the government agencies. So this UCC does not impact or affect negatively Bitcoin being utilized in transactions. I think that is just a mistaken misinterpretation, or maybe not a full understanding of what the UCC intends to do with these specific new laws or new code that would cover commercial transactions. Carla Reyes, some of you may know her. She's an attorney that has done quite a bit in the emerging technologies and blockchain promotion over the last few years, was involved with the UCC in this, or with the ULC in these UCC amendments. I just want to read a quote that she provided. The UCC is not regulatory in nature, and the definition of money in the UCC has no direct impact on the definition of money for other legal purposes, such as in the taxes, anti-money laundering, money transmitter regulations, security regulations, commodities regulations, or even which mediums of exchange serve as U.S. legal tender. The definition of money in the UCC serves a narrow commercial law purpose to provide predictability and stability in commercial transactions relating to a specific type of medium of exchange. The unique and decentralized nature of Bitcoin and other cryptocurrency require a different approach to enabling stable and predictable commercial transactions involving those assets. Because of their nature being different than fiat, that is why they needed to be defined differently, even though Bitcoin could technically have been defined as a fiat currency, but because it is handled differently, it does different functions, it could not be defined as money. So right now, the Article 12 of the UCC is to establish that framework between the states for a better understanding of how cryptocurrencies can be used in these fields, such as commercial transaction, again, lending and security interests. Bitcoin is a medium of exchange. It's a measure of value. It's a system of accounting. Within the context of the UCC, it should not and is not money, fiat currency, or legal tender. There's I can't remember if it's Kierkegaard or some other philosopher that said, to define me is to limit me. I firmly believe that Bitcoin being defined as money would limit its potential utilization and cause even more problems than would be the nature if it remains as a controllable electronic record. It does not limit Bitcoin in any way from being utilized in transactions, security interests, lending, etc., by being defined different. So I think that's been about, looks like almost a half hour, I guess, that I've gone on there. Wish been able to do the slides a little bit, might have been able to cover a little bit more. But that's the overview of the UCC, of what it's intended to do, how it came about, and where it's going. So I will turn it back over to Dennis. I want to thank you all for giving me this opportunity to speak, and I think we're going to have some discussions. I'm more than happy to address any questions, or if it's an open discussion, that'd be good with me as well. We can open the floor. I'm sure there's several attorneys on that have specific takes, and actually I'm sure there's many on here that have looked into it. So Dennis, I'll turn it back over to you. And
this is Gordon Jones. Got a quick question. So what's the status of the UCC in South Carolina? Do you know?
As of right now, I've been talking to Dennis, recommending that South Carolina do put these forward, or try to pass those. I think South Carolina's sessions just started, so the hope is that they will look into this and adopt these, so we can move forward with a better understanding of how to utilize these controllable electronic records, and to actually have that framework so we can develop the industry. Without that foundation and understanding within a legal framework, I think we're still going to be Wild West all over the place, and just you're going to have bad actors or incompetent actors or failed actors that are continually hurt the industry. So without that basic understanding amongst the states and how they will be handled, I think we're going to continue to kind of flounder and run off in different directions. So my hope is that South Carolina is able to have these put forth to be discussed and potentially pass this session. But that'll have to be, I'll have to turn that to Dennis for where this may stand.
And let me just address that directly. The current status, to the best of my knowledge, right now is that the amendment has been drafted. It's essentially waiting to be introduced. And we have 4 ULC commissioners that are involved with it. They have basically a high level understanding of it. I suspect that probably not as extensive as we've spent on just in the last 30, 45 minutes. And there's certainly a lot of education to do on that level. So obviously one of the conversations I've had with Brian in the past is that a lot of this is really designed to establish a common taxonomy. And in the wake of the FTX scandal, obviously what's going on now with the banking matters in DC, part of the motivation for putting this program together today was really to try to get at least a spotlight back on this, because we made a decision as an organization, the language associated with the Wyoming legislation. And now that the UCC language has been established, using that and trying to educate, for that purpose, for South Carolina to adopt it so that it doesn't have to change things later on, or completely redrafting our legislation to marry up with the UCC language. So, as just a matter of legislative economy, and policy direction on our side, we chose to focus more on how we could attract more industry into the state, through really the sticks and bricks side. So for that, I'll leave it open. I'll take one quick minute. There is no completely free lunch. I'm going to go ahead and post in the chat a link to our conference store where you can get memberships to the association, along with a discount code of 40%. And then I'm going to hand it off, and open it up for questions to Brian or with some of our attorneys in the group if they'd like to comment on their thoughts. I'll open up the floor.
One thing I'd like to add, South Carolina was asked, I believe that was Gordon that asked about South Carolina. With Kentucky, I just looked because the UCC had passed the Senate and had gone to the House. I was waiting for the Judiciary Committee to meet. They were meeting today as we were talking. While waiting for the meeting, they kept on sending it back to the House to get, Kentucky requires 3 readings before passage. So they've already done the first 2 readings, sent it back to the committee, and it was discussed today in committee. I don't know how that turned out, but it appears that UCC, as of right now, based on what I'm looking at, that it will be passed in Kentucky. Also, I'm pretty sure the governor will sign, because the gentleman I mentioned before that is the UCC, I guess he's the UCC champion in Kentucky. His son was just elected a U.S. House congressman, the only Democrat federal elected official from Kentucky. And our governor currently is the only elected Democrat at the state level. So do not see any objections there. So as long as it passes the House, I'm pretty sure it'll be signed. So it looks good for Kentucky. But I'll turn it back over to everyone for questions or discussion.
So I want to just recognize Graham Newman just posted in the chat for everybody's benefit. the status of legislation across the country as a link. So you may want to grab that and set that aside for to keep track of this. Any other questions? Can we?
So
yeah,
the link posted by Graham.
Discussion. Sure.
Yeah, the post the uniformlaws.org. They do have a lot of information if you want to find out more specifics. They have a lot of documentation of overviews. They have summaries. This is a lot of the information that is provided to the legislators to look over to better understand. They also have 2-hour-long videos that explain the process and go into greater depth on some of these other items that I sort of glossed over, dealing with transfer, as well as dealing with the chattel paper and how that has changed into electronic forms. They have an hour on the specifically digital assets aspect, and then another hour on the other miscellaneous changes that were made. So those are all great resources if you want to find out more, but it's at that uniformlaws.org. You can find that.
I'll just raise the question going back to taxonomy. Obviously, with what's going on with Senate banking committees, the legislation that's been introduced. I mean, how does this all tie in with each other? Obviously, the states are now obviously we've got one set of laws that originated out of Wyoming with a level of taxonomy. We've got the UCC now, that the ULC that's spent 4 years really since 2020. I believe it's 2020. 3 years now. I had the privilege of attending the first meeting of the Emerging Tech Committee in D.C. And at the time, I mean, there were 50 attorneys in that room, and probably another 5 on the conference call, and they've been working diligently, for the last several years to get to this. Same time, we see what's happening at the federal level with number of bills being issued there. I mean, how do we reconcile all this language and the commonality and why? I guess the question is, my real question is, why aren't our congressional offices recognizing what the UCC's done, and using that potentially as a springboard as well?
Well, I cannot even presume to understand Congress, so I'm not even going to address that question. I don't even want to guess what they're thinking. I think the taxonomy has improved. I think that's, as you mentioned, the UCC using the controllable electronic record is the best definition. It definitely focuses on what virtual currencies, and as we get into virtual assets, securities, fixed income, financial instruments, as those become more prevalent, it best defines what these are. They are controllable electronic records, whether they have an underlying value or not associated with them. The digital assets was so broadly defined, one within the UCC, but that was utilized as well in the initial changes by Wyoming. That digital assets, I think, is too broad of a definition because it can cover so many different things. I think taking these down to specifically addressing the financial aspects of blockchain, or the language is very agnostic. It doesn't identify a specific technology to provide for future developments within electronic finance, to allow a process to be in place that doesn't really need to be altered much. So I think by focusing in on exactly what we are talking about, controllable electronic records, it's going to provide that better understanding and that legal framework for banks and other institutions that are going to eventually, and they will eventually be involved in this, to understand, where are the rails so they don't go out of the off the path. Uh, it'll help them better understand it. And again, as I mentioned earlier, with the conservative nature of banks and the regulations they always have to be aware of, it's going to provide them that framework to understand how to transact in these new intangible assets.
Questions? Well, if there are no questions, obviously I want to take an opportunity to thank everybody and certainly apologize to Brian for my, for having our hosting process a little bit, unfortunately not exactly right. Everybody has a copy of the slide deck, and can certainly reach out to Brian if you have any additional questions or looking for any additional input. Obviously, the question of education is an important issue. How we proceed in South Carolina to assist our legislators and understand the benefits of the UL language, and obviously how that may potentially into our congressional delegation education. We feel as though South Carolina is a small state, has the ability to influence, discussion through a concerted effort of education as a grassroots effort. I want to remind everybody that we were successful in receiving an appropriation for the Treasurer's Office last year for education, digital currency literacy in South Carolina. That could be very broadly focused on a broad platform for public education, as well as a narrow platform for understanding the nuances to policymakers. So our South Carolina is to stay on the forefront of policy matters associated with emerging tech. So if there are any other questions, we have a few more minutes. We can stay on. If not, obviously, I want to thank everybody for attending and ask you to, keep your calendars open and look. Obviously, the announcements for the Virtual Learns will be going out as we continue to fill that slate, and we look forward to obviously everybody joining us in October. I do want to mention real quickly. There is a half-day event at the University of South Carolina, Darla Moore. The Faber Center is hosting Blockchain's Business. It is not Bitcoin, but more blockchain and actual uses of blockchain as part of a tech stack for business application development. We've got some terrific speakers that we've lined up. To assist. South Carolina Emerging Tech is the title sponsor for that event. Faber is hosting it. We'll be hosting Greg Landegger, investor in early stage companies, has been involved in this space for many years. We're also hosting Eric Lappin, who is, through Form Free, has created a new method of establishing credit scores to expand, financial inclusion and increase the opportunities for folks to buy houses. It's being looked at very closely and incorporated into both Fannie Mae and Freddie Mac qualification requirements or opportunity underwriting guidelines. So we also have Sophia Lopez, who will be joining us from Kaleido, one of the top with CBDCs and a number of other vertical applications. Joseph McKinney will be giving us an overview of the Cadaba Zone, North Carolina, and how they've implemented a whole host of regulations to go after Delaware's business and Wyoming's business. So It's going to be a terrific. Gordon will be presenting on validity, so I want to invite everybody, see everybody that can make it into Columbia on Friday. It was specifically set so that if you're coming in from any other part of the state, you don't have to get up at the crack of dawn or too early. You'll get to Columbia and join us there. So if there, we can, stay on for a little bit longer if discussion or wide open. I'll just open up the floor at this point, and we can officially the UCC language, or presentation at this point. And I want to thank Brian for his participation and all the time he putting this together, and look forward to seeing him in South Carolina at the conference in October as well.
Just wanted to thank you for letting me speak, and definitely looking forward to October. Wish I could be there Friday, but it's my 20th wedding anniversary, so don't think I'll be allowed to get away.
Well, Charleston's always a good place for an anniversary. And it is St. Patrick's weekend, so it is going to be pretty busy. So well, I mean, we started this before folks came on. If you'd like to just provide a little introduction, I can, we can continue going around the room. Graham was one of our newer members. If let's put it this way, if you unmute, I'm going to call on you. If you don't unmute, I'm not going to call on you. So we'll leave it. We'll leave the opportunity to discuss more topics with that.
Yeah, so I'm a lawyer, and I saw the topic of conversation today, and I said I didn't realize there was an Article 12 to the UCC. I'm embarrassed to say that I also didn't realize there's not yet an Article 12. So I'm very interested in seeing the development of this legislation. Just as a caution to everyone, the devil in the details of this type of uniform stuff is once it gets in the hands of the legislature, they tend to think they're smarter than everyone, and they start trying to tinker with this stuff. And the problem with that is once the various state legislatures start moving pieces around, you start losing the advantage of the uniformity of the law. So hopefully the legislatures will all do their best to stay on their best behavior and not begin moving pieces around and creating an even bigger mess than we have right now. So we'll see. Good luck, Brian, and you're wrestling with that beast.
That's what it is. But yeah, hopefully it goes well. Well, the good thing is, I think if Texas passes the UCC, I think it's got a better chance of going, because a lot of states, I know Florida, we're trying to get it proposed. I'm actually in Florida. We're trying to get it proposed down here, and with the FTX and everything going on, and now with 2 banks going under, and they're trying to blame it on crypto. Everyone wants to stay as far away from that as possible. But Florida looks to Texas as its competitive, its antagonist, its opponent. So if Texas does it, I believe you'll see a more broad acceptance. I can also see potentially the South Dakota overriding the governor's veto with a better understanding of what this does. I'm just guessing there. I don't know enough about South Dakota politics, but you're right with the uniformity. In fact, I believe Louisiana never has actually adopted the original UCC. So there's not really a uniformity within the uniform commercial code, but for most states have adopted it, and most of them are close enough. Just having it in some states, I think, will better solidify foundation for future development and better understanding. So yeah, hopefully they don't think they are smarter than they are, but as you said, they can't help it.
I see Gerald Gallagher just joined us, and if you'd like to weigh in, just potentially on your background and knowledge with UCC. I know you've had obviously involvement in DC and at high levels along those lines. Of, we're really just kind of in an open discussion at this point. But I want to thank you for joining us, needless to say. May not be able to hear it yet, well, if there's anybody else that would like to, a hand and just for introduction purposes. If not, we've got just a couple more minutes, and I will thank everybody for joining us, and we will look forward to the next installment of South Carolina Emerging Tech's virtual BYO Lunch and Learn. So there you go, Patrick.
Yeah, just wanted to thank you, Dennis, and the team for putting this on, and of course the speaker. Not a topic I know a lot about. I'm the CFO of a clean energy Bitcoin mining company, ex-CFO of a company that focused on blockchain-based central bank digital currencies. So certainly some stuff in here that could potentially affect my current work. So interested in it, and thanks again. That's it.
Oh, my pleasure. Thank you. And just to your point on the energy, on the clean energy side of Bitcoin, if anybody's following Dennis Porter on Twitter, he has been, trying to raise the alarm for a hit piece that's coming out on the New York Times on Bitcoin mining, and attempting to refute a lot of the facts that have been established to date. And really trying to what particularly caught my attention in that, Patrick, was a new method of trying to establish whether the green reference is in fact so. I mean, by so they're trying to basically saddle the energy mix that may go into a Bitcoin mine that Carolina, where we have nuclear, we have coal, we have solar, everything goes down to. And if you're located close to the nuclear plant, you may be able to establish that you're 100% nuclear energy at that point. In this case, they're saying that basically the end user is the one that gets or is determined to be the dirty player, if you will, as opposed to the generation point. So I just encourage everybody to if you're on Twitter, at this point, just check out Dennis's posts, and with Satoshi Action Fund, he's been very instrumental in helping us in South Carolina, and we want to support him everywhere we can.
Yeah, so I second that. I'm not associated with it at all, but Satoshi Action Fund, if Dennis is right, we're definitely worthwhile following, and following Dennis on Twitter. I agree.
So, time to back to work, folks. So we want to thank everybody for coming today, and look forward to to the next installment of our BYO Lunch and Learn. Thanks so much.
Thank you.
Thank you, everyone. Thank you, Brian. Thank you, Dennis.